Hi there, I'm Savannah Mextro with Manor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney Robert Manor. On today's webinar, we're becoming Power of Attorney Mythbusters as Bob dispels some of the biggest myths surrounding these essential documents. Before I pass the torch to Bob, I'd like to cover a few housekeeping details. First of all, a disclaimer, and Bob will cover this later, but today we're not giving out any legal advice. While today is informative, educational, you'll definitely learn something. If you're looking for legal advice specific to you, please contact us after the webinar. Also, remember that today's webinar is recorded. We'll send out a replay link later this week, probably tomorrow, that you can share with your family and friends. Also, remember that if you do have chat box, if you do have questions, this webinar is live. So feel free to put your questions in the chat box and we'll review those questions at the end of today's webinar. If we don't get to your question, we will contact you after the webinar to make sure that you get an answer. Now, why should you listen to what the folks at Manor Law Group have to say? So first, you can know that we are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. My personal favorite reason is that Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. We're pretty proud of that. Now, without further ado, I'd like to welcome Attorney Bob Manor.
Hi, folks. We're going to get right started here. And so when we're talking about powers of attorney, I always like this cartoon. Well, I was bitten by a radioactive lawyer, and now I've ended up with power of attorney. So kind of a funny little take on that. The idea here is that we're going to talk about what powers of attorney are. Savannah has done a great job on our social media page and our Facebook and such, because what she's done is she has had these question and answer sort of mythbusters that she's been doing on Facebook, and there's been a number of them on power of attorney that I've been watching lately, and it's really interesting. The last one was, what do you call the person that you appoint under power of attorney? And she gave lots of answers, executor and agent, and the answer is actually agent. You appoint an agent under power of attorney. So I thought we'd start off with that and refer people back to our Facebook page because Savannah's been having some really fun things on there as far as questions and multiple choice questions that you can participate in. So those are always fun. All right, so let's go to the first myth here. The first myth that I have is a power of attorney is the same as guardianship. Well, often, this is really an important one, actually. And the reason why this is really important is that frequently we'll get a call and the call will say, I've been told I need to get a guardianship. My spouse, my parent is in the hospital. My spouse or parent is in rehab or the nursing home. Or I've been told by a social worker that we need guardianship, or I've been told by the banker, or I've been told by my financial advisor, I've been told by whoever we need guardianship. And the answer is guardianship is a court process, and power of attorney is where you don't need the court process most of the time, where power of attorney is you've appointed someone to be able to make decisions for you. And so often, most of the time, the vast majority of the time, we are able to avoid having to go to court if we have a sufficient power of attorney. And that is a good thing for most of us. And so we want to make sure that there's no issues with going to court and that we have a chance to do that. Plus, we get to decide in advance who is our power of attorney. So we get to decide it rather than the court does. Some of you may have seen, depending on where you're watching this from, some of you may have seen that there's been lots of stories in the news over the last few years. In fact, it got the attention of the Attorney General and the governor, and they have this whole task force dealing with guardianship abuse, where the courts are appointing these strangers to be over the money and over the person. And there was the case in the Detroit area where the guardian spent $400,000 in a period of 6 months, and really wasn't necessary, and kind of kept the family away from them and things like that. There's been awful stories from all over the country relating to that. Now, and not to say that the guardianship isn't sometimes necessary, and that the judges often are doing their best, but there has been some abuses, and the governor and the Attorney General's task force has been tasked to try to work on that. And so the idea here is when we get a call saying that somebody needs guardianship, we certainly are going to look into that, but there's always the possibility that they could still sign a power of attorney, or that they already have a power of attorney. And that is often the case, that at some point during their life they had drafted a will. Well, most lawyers, not all of them, but most lawyers, if they drafted a will, they'll at the same time you draft the will, you say, well, you probably should get power of attorney. Now, I know that doesn't happen all the time. There's a number of lawyers that you ask for a will, you get a will. A lot of lawyers that sort of focus their practice on estate planning will do their best to make sure that somebody doesn't leave their office with just a will, because the will only takes you so far. We need to be looking at the power of attorney documents. So that's the first of the myths that we're going to be looking at. Let's see. Okay, so this is the power of attorney basics. It's not that complicated. It's pretty simple, right? Your ability to act versus your needs and wishes, and why you need one. So making sure that those things happen. So instead of having a court-appointed guardian or a court-appointed conservator, they refer to that if somebody's going to be in charge of your money. In Michigan, it's called a conservator. If you're in charge of the person, it's court-appointed is going to be a guardian. But many times we can avoid that by appointing someone ahead of time and doing that without court involvement. And so basically the idea of having a power of attorney is making sure that your needs are met and that your wishes are met. That if you want to have your spouse to be able to interact for you or make medical decisions for you, well, this is your way of doing it. If you want to be able to interact with your kids, if your kids were to, if they're over 18 and they were able to, they got in a car accident, did you know that you couldn't necessarily get information from the doctors or from the school? If there was an incident at the school, you can't necessarily get information or help make decisions for your 18-year-old or 19-year-old unless we have power of attorney for them, unless you have power of attorney. So you're basically appointing somebody that you trust and you love to make sure that your needs are met and your wishes are carried out. And there is a lot of trust there. That is very important, but that's the basic idea. Now, guess what? If you don't have anybody that you love and you don't have anybody that you trust, shouldn't have power of attorney. Bottom line. I mean, you might love them, but if you don't trust them, should not have power of attorney. That is the bottom line. It is very important to know that this can be abused, and I have all kinds of awful, horrible stories about people abusing this. But the bottom line is, for people that they know that they have somebody that they love and they trust, then we can certainly make that work. So, all right. My next myth is that all powers of attorney are the same. And this is definitely not true. In fact, we're going to specifically be talking about the differences between a medical power of attorney and a financial power of attorney. But there's lots of powers of attorney out there. There's, the general durable power of attorney, a general financial power of attorney. Well, real estate. So many years ago, when I think it was I bought my first house, I think it was many years ago. And what happened was that the seller had already moved out and had moved to Florida or Georgia or something. And they were not going to come back for the sale. And so what happened was the seller had appointed his mother to come in and sign at the closing. And so we had somebody to come in and sign the closing, and he wasn't required to be there. Well, that kind of power of attorney, that's kind of what we're talking about. But that would be what would be referred to as a special or limited power of attorney. And it was limited in time and scope. It said, I'm giving my mother power of attorney to be able to sign the closing documents necessary to sell this house. And it is limited to this day and this piece of real estate, and that's the only authority it has. Whereas the general durable power of attorney is going to be fairly broad. What's interesting about that, I've seen powers of attorney that are drafted, and people will come in with these things, and it might be one page, and it says, I appoint my daughter to be my power of attorney, and they can do anything I can do. I mean, it might say more than that. It might be a couple paragraphs, but basically they try to just make it a catch-all that says, and they can do everything I can do. And the answer is, guess what? Most of the time, that's not going to work. That's not going to work. Lawyers are lawyers, and judges are judges, and the court's the court, and the system is the system, and it is what it is. I don't have to like it. I'm just telling you the truth. And if it doesn't have the proper language in there, we have a very comprehensive power of attorney, and every once in a while we'll get a credit union or a bank or somebody to say, well, if it was just worded this way, then we can do that. Well, we usually find a way to work around it, but the bottom line is, even with our very, very thorough power of attorney, we'll still get calls occasionally from somebody saying, well, it doesn't have the language sufficient, even though it says they can do everything, or they can interact with the bank, and they can change beneficiaries, and they can do this, and they can do that. And the thing is, if it doesn't have the language exactly the way that for the circumstances, we might not be able to use it. So let me focus on a couple of key distinctions for power of attorney basics: financial durable power of attorney and healthcare power of attorney. Now, sometimes that healthcare power of attorney is called different things. Sometimes it's called a patient advocate, and sometimes it is called this isn't perfectly accurate, but people will sometimes refer to it as a living will, or even a DNR, which it's not. It's not a DNR, and I'll explain the difference in a second here. But the bottom line is that it is something that we know that these have to be separate documents. And some people are really surprised by that you actually cannot just bring in one document that says power of attorney and do all the things that you need to do. You actually have to have separate ones, and they only can do those things that are specifically and usually in detail laid out, which is why the form documents aren't really going to solve your problem most of the time. But I will have occasionally, well, frequently, very, very frequently, I'll have somebody bring in a power of attorney, because I ask them if they're coming in for their mom or their dad or their spouse. I'll say, well, if they're not going to be at the meeting, can you bring in your power of attorney? And they say yes, and they bring in a document that says power of attorney on it, and I say, well, this isn't going to work because it is a healthcare power of attorney. And they say, well, it says power of attorney. Well, all documents are not the same. There actually are two separate documents. And in Michigan, it's actually required that they be two separate documents. It's because there's a different standard for when they're invoked and when they're used. And so for the financial durable power of attorney, you can have it be effective immediately upon signature, which is actually what I recommend. And I'll explain that in a second. Or you can have it effective only on disability, where it springs into effect if two doctors declare you disabled or incompetent. And the thing is, then the healthcare power of attorney actually only has the ability to go into effect if you've been declared incompetent, if you've been declared on that given time that you are unable to manage your medical decisions, okay? And so you always get to make your own medical decisions. You cannot appoint someone to make your medical decisions when you're still capable of it. It's an interesting part of sort of constitutional law and self-determination, is that you always get to make your own decisions when it comes to medical, as long as you are able, as long as you're conscious, and as long as you're competent. And that would be determined by the doctors as to whether you're competent or not. Whereas a financial durable power of attorney, there's lots of times that we're going to invoke that when you're not considered incompetent or you're not unconscious. And so there's different standards in which they're invoked. There are different standards in which they're used. There are different sections of the law, and they really need to be in separate documents. So the financial durable power of attorney, why do I say that should be effective immediately upon signing? Well, it comes right down to this. You either trust somebody or you don't. And if you don't, or if you have any qualms about it, then we shouldn't sign that power of attorney, or we shouldn't make them the agent under your power of attorney. This is really, really important. You do not want to give somebody authority to interact and mess with your finances if you're not 1,000% certain that you can trust them. And so my point is, if you are 1,000% certain that you can trust them, why wouldn't we make it effective immediately? If the ones that are called springing powers, or that they only take effect on disability, my concern about that, I have two concerns about that. One is that, well, if we can't trust them when you're alive and well and competent and you can watch what they're doing, then how can we trust them when you're at your most vulnerable? So we either trust them or we don't. If we don't trust them now, we shouldn't trust them then, right? The second reason is banks and others, anybody that we interact with, have been through the years making it much more difficult to use a power of attorney. So, and any walls that they can put up, any barriers that they can put up, will often say, well, we're just not going to accept that. And so anything there's a couple examples that I'll give you about why banks will, or others will say that, power of attorney, that they'll put a barrier to it. One is in the event that it's a springing power, and they say, well, that they make it much more difficult to deal with, we're putting up a barrier there. Another one where sometimes they will put a barrier there is if it says, I appoint my son or my daughter, or I appoint my son and or my daughter, or I either, or I appoint my son and my daughter, or my daughter, any of the options there. They'll often make it very, very difficult to use that document, because they say, well, I don't know that son and daughter are going to agree, and I don't know they're on the same page, and how do we know this wasn't fraudulent in the first place? I mean, even a perfectly drafted power of attorney, we're often have challenges with the bank. And yet, if we put any barriers or we give them any excuses, it gives them even more likelihood that they're not going to accept it or follow it. This is a big issue. It's such a big issue that there's actually legislation that's being considered in Michigan right now to make it where there could be some penalties for a bank not accepting a power of attorney. Right now, it's really difficult to force the bank to accept the power of attorney. And we're going to talk about, well, how do you get around that and what's a better plan in a second here. Well, actually near the end of the presentation today. But I'll just tell you, I had this live presentation I did in person several months ago, and I was telling people in the audience, well, sometimes banks just won't accept the power of attorney, and somebody in the audience was just incredulous. They said, how, but wait a minute, is it a legal document? Yes. Is it enforceable? Yes. Is it binding? Yes. Is there anything wrong with it? No. And you're telling me the bank won't accept it? Yes, I'm telling you exactly that. And they were really, surprised by that. But we hear it all of the time. In fact, I wrote a blog article about this many years, probably 10 years ago, and I still get calls occasionally from paralegals or attorneys throughout the country who will say, well, how did you get around that? Because I'm having this bank that won't accept the power of attorney and won't let us do what we need to do on behalf of our elderly parent or our spouse or, whatever it is. So it's really important to have that crafted in the best way possible and put the minimum barriers on there. The healthcare document is going to be a lot different, because that's going to not be dealing with banks and things like that. It's going to be dealing with making decisions in an emergency. It might be making decisions in a mental health context. It might be making decisions in a dementia context, right? And so with the healthcare one in particular, a lot of people don't think about that until they get sick. Well, guess what? If you're already sick, you might not be able to sign a power of attorney, and then we have to go into court and pursue that guardianship option. So one just little quirky thing in Michigan, and this is different in different states, but in Michigan, the court equivalent of a financial durable power of attorney would be called a conservatorship. And the court equivalent of a healthcare power of attorney would be called the guardianship. All right, so next myth. Any power of attorney will work for mental health and dementia issues. I just kind of foreshadowed this myth here. It's not true. Most powers of attorney, in fact, the vast majority of powers of attorney, I'm going to suggest just a minuscule number of them that I've reviewed, and I've been doing this for close to 25 years, and I've looked at a lot of older power of attorneys or other lawyers' powers of attorneys. They don't deal specifically with mental health issues, and here's where the problem comes in. It's not just mental health, it can also be dementia. And what it does is it makes it so that it can be where we really can't enforce that document. I know that sounds odd when it comes to mental health and dementia, but let me tell you the story. There was a case that went to the Michigan Supreme Court. And it was an interesting case because grandma, in this case, was in the hospital, and they had found her in her home or whatever the situation was and fell. Something happened. She went to the hospital, and then from the hospital said, oh, well, you need to go in for rehab for a little bit. Well, she had dementia and she had other medical issues, and she needed, both from the standpoint of dealing with the physical therapy and all of that, she needed that to get stronger. But then the hospital and the rehab place said, and you really shouldn't go back home alone. It's not really a safe situation. And fortunately, she had appointed her granddaughter, who lived nearby, as her medical power of attorney. And so the rehab place said, well, Grandma, I'm just going to call her Grandma. Grandma, you need to stay here and you need to do your physical therapy. And once you leave here, you probably need to, make some arrangements so that you're not alone anymore, because it's not safe because of your dementia and other things. And at first she was fine. She said, okay, well, if that's what my granddaughter thinks, then that's what we'll do. And then we had the out-of-town relatives come into town. And we have a little joke in our office about out-of-town relatives that don't have any context of the situation and just have this sense of guilt that their grandma or their mom is never going to be in a nursing home. And, that they say they'll fly into town and make demands and then fly out and never call. And so we call those seagulls. And the seagulls, the joke is that we're the out-of-town relatives that are barely in touch with grandma or mom, fly into town, poop all over everything, and then fly away. And the idea is that's what happened in this case that went to the Michigan Supreme Court. They came into town, they got grandma all riled up, and they said, Grandma, you're never going to be in a nurse. My grandma will never be in a nursing home. Well, she was only there for rehab, and after that, they were going to try to make arrangements so that she was in a safe place. Or get care in her home or something, but the out-of-town relatives didn't care about any of that. They just simply said, you're not going to be in a nursing home and you should just go home. And so they got grandma riled up. And so grandma told the staff at the rehab place, she said, I'm going home today. And they said, oh, you can't. You had signed this healthcare power of attorney. You appointed your granddaughter, and the doctors say that you're not competent to make this decision. And so, this has all been done. And she said, all right, well, give me that document because I'll tear it up. Oh, well, that's interesting, because under Michigan law, it's right there in the statute. Under Michigan law, you can tear up your healthcare power of attorney even after you've been declared incompetent. And that's what this woman wanted to do. And there was this big lawsuit about it. It went all the way up to the Michigan Supreme Court. So there is a provision in the law, specifically as it relates to mental health issues, or what I reference it is for dementia issues, where we say, okay, when you're competent, when you're signing the power of attorney, because you can't sign it unless you're competent. When you're competent to sign the power of attorney, back when you were healthy, you can decide to give yourself a 30-day cooling off period. And so basically it says, I understand under the law that I have the right to revoke or tear up this document even after I've been declared incompetent. But I can imagine a situation where I've been declared incompetent and something goes wrong. Maybe it's a temporary thing and it's a urinary tract infection. I just need an antibiotic, but I'm not willing to participate. I'm not willing to take the antibiotic. I'm not willing to stay in the hospital because I don't know. I don't understand it. I've been declared incompetent. And I want to allow my granddaughter or my daughter or my spouse or whatever to be able to make that decision for me for up to 30 days. In other words, it's kind of like a cooling off period. So we've built that into our documents most of the time. It's an optional feature. You don't have to have that in there. But the vast, vast majority of documents I look at don't have that provision in there. And if it doesn't, guess what? You can be like the grandma that went to the Michigan Supreme Court and tear up that document, and it was not safe for her to leave. And everybody knew it, but the out-of-town relatives didn't understand the context of what was going on. So very important myth buster there. Next myth, you can use any kind of form document. Well, I'll tell you what, I guess if it's better than nothing, right? Better than nothing. It's honestly, first of all, you should not sign your life away with some form that you got off the internet or picked up in the Office Depot. You're literally signing your life away, possibly medical decisions over your bank account, decisions over all of your investments, your IRA, your house, everything. You're signing it off on a form that you picked up at Office Depot or got off of LegalZoom.com. And, in a situation where I guess something's better than nothing sometimes, but sometimes something can cause all kinds of bad problems. And so it's really important to take these documents seriously. Most people wouldn't be foolish enough to try to write their own trust. A trust is a complicated legal document. Most people wouldn't be foolish enough to, unless they're an experienced lawyer or experienced business person, to write a buy-sell agreement on a business or something like that. This is just as important, both your life and your finances and your house and you're protecting your family, all of that. It's just as important. Don't look at it as, oh, I can just do a fill in the blank form. I guess you could. I seriously don't recommend it. I think that's a really bad idea. I like this one. This is one of my favorites here. So you see this on TV a lot, right? There's always movies about this where we have Rocky Balboa gave his agent, his accountant power of attorney, and next thing you know, Rocky Balboa is poor. Or all these rich people that they gave somebody power of attorney and they're poor. And so sometimes we'll have kids that will think if they got power of attorney for mom or dad, it means that they can do whatever they want. So the cartoon here is, we're thinking about giving you power of attorney, and the kid says, I'm rich. No, guess what? Kid can go to jail, should go to jail, hopefully will go to jail. And this is, again, one of the things that the Attorney General's task force is working on, trying to strengthen some of those laws. Now, we got to make sure that they don't strengthen them too much and hurt the people that are really trying to do the right thing. But the bottom line is, you cannot use a power of attorney to benefit yourself. And if you do, you should go to jail. And so it doesn't mean that you're giving that authority. Now, again, you got to be careful. So my law school professor, I had this law school professor for wills and trusts, and I don't know. I mean, I know I was in my early 20s at the time, so for all I know, he was probably like my age now. But to me, he seemed like he was 110 years old, and he was a funny little guy. And he used to call the power of attorney a license to steal, and in fact, it kind of is. In other words, if you take the power of attorney to the bank's supposed to let you take the money out of the bank. And so, is it legal? No, you can still go to jail for that. If you take the money out of the bank and go to the casino, you absolutely can go to jail for that. But the bank's not supposed to stop you from doing that. Now, some banks, put some safeguards in there, and that can be a good thing. It also can be, a challenging thing when people are trying to do the right thing and they have to jump through all these hoops. But the bottom line is, when you give some power of attorney, that doesn't mean they can do whatever they want. They have to use it as the legal term is called a fiduciary. They have to use it to benefit you. We have in our documents, again, reason not to use a form document. In some families, it's appropriate to loosen those restrictions. We got to make sure it's the right person and it's the right situation, but there's sometimes we want to loosen some of those restrictions, but still to benefit the person that is appointing you, to still benefit mom or dad. So if mom or dad is appointing their spouse or their kids, it's for their benefit. And so the example of this would be appointing somebody in case dad goes into a nursing home. Well, if dad goes into a nursing home, he can't authorize the transfer of money over to mom. You'd think that would be fine. They've been married 50 years. Transferring the house over to mom should be able to do that under a power of attorney. You can't always do that, and most of the time you can't do that under a power of attorney unless it has specific language authorizing that. Or mom's passed away and dad's in a nursing home, or is there anything we can do to protect some of his assets and not lose everything because of Medicaid? And the answer is yes, but we have to have the authority to do that. And by the time dad is in the nursing home, he probably isn't capable of giving us that authority. So he has to kind of pre-authorize that. We call that extraordinary powers, or an extraordinary power of attorney in our office. Again, you're not going to get that on a form, and you shouldn't. Oh my goodness, if that was on some form document, all kinds of havoc could be there. But under the right circumstances, it's really appropriate. And another reason why just a standard form document is not appropriate. All right, next myth. If you have a will, you don't need a power of attorney. This is actually an interesting one. Occasionally we will get this, that, folks, they just don't think too much about it. They just, they've never really went to a lawyer. They've never really thought much about it. And they decided to go to a lawyer when the kids were young, and they got a will drafted. And honestly, they probably should have gotten powers of attorney at that time too, but they didn't. And so fine, that should be fine. All I need is a will, right? Well, when does the will take effect? Not in lifetime, but not even after death, right? Will doesn't take effect until the court gives it effect, until the court issues what's called a letter of authority. The will has to go through probate to get a letter of authority for the will to have any legal authority. And so the will definitely doesn't have any effect. I will occasionally have kids come in and they say, well, I'm the executor. Well, the executor is a term that's used sometimes for, managing an estate after death. I say, you don't have any authority whatsoever. Mom and dad are still alive. As an executor, you have no authority, okay? So the will is not necessary. So then I have the opposite myth. If I have a power of attorney, I don't need a will or a trust. That's not true. Power of attorney is going to die when you die. So you do not, the power of attorney will not survive your death. If you've appointed an agent, they're not going to be able to go to the bank for you afterwards. They're not going to be able to sell the house for you afterwards, things like that. So I have this slide here that I like. The myth is the power of attorney survives death. No, it does not. The picture, of course, is a ghost with his lawyer, and the lawyer says, my client wants his power of attorney back with his ghost. His power of attorney does not survive death, whether neither healthcare or financial. One of the things that we do always when we're doing these documents, we always are pretty insistent that we also do a HIPAA waiver, healthcare privacy, HIPAA waiver. And some people say, well, you don't need that because if your documents are HIPAA compliant, then you don't need the HIPAA waiver. Well, we actually want the HIPAA waiver because we don't want to have to invoke a healthcare power of attorney. We don't want to have to invoke a financial power of attorney in order to use the HIPAA waiver. Sometimes we want to be able to have access to medical information without having to declare somebody incompetent or whatever else. And certainly after death, we want the HIPAA waiver to survive death. So HIPAA, healthcare privacy, where your family could get access to your medical records in case the doctors did something wrong or something like that. But the documents themselves will not survive death. Myth, I can never revoke my power of attorney. Okay, of course you can. As long as you're alive and competent, and even after you're competent, you can revoke powers of attorney. So for a financial one, you can certainly revoke your power of attorney at any time. If you're incompetent, can you revoke a financial power of attorney? Well, that's a little bit more up in the air. But it is very, very clear under law that you can revoke a medical power of attorney or a healthcare patient advocate even after you've been declared incompetent. So you have the right to revoke your healthcare power of attorney even after you've been declared incompetent. That's why we put that language in there that we talked about earlier that says, well, sometimes, I mean, it's optional, but in the right circumstances, we put the language in there that some people will decide that they want to have that 30-day cooling off period that says, okay, if I'm in a delirium. So delirium is not quite dementia. It's often misdiagnosed as dementia, but delirium is all of the trauma of the fall, all of the, maybe the medications they have you on, being in the hospital and having them wake you up every hour and not getting proper sleep and not having your glasses and having some memory issues, and all of a sudden it seems like the dementia just went through the roof. Well, that's actually delirium, and it's often misdiagnosed as dementia. So maybe you're in this delirium state and you really need to get that treatment. You need to kind of stabilize things. You need to get that antibiotic or whatever it is. And the idea is if you tear up that document, or if you have the right to tear up that document, but you have that unless there is a provision in there that identifies the statute that says that we can have this 30-day cooling off period. But even at that, after the 30 days, if you still want to revoke that document, you can. You can't extend it under Michigan law. You can't extend that beyond 30 days. Okay, next myth is you only need a power of attorney once you're sick. We get this so often. We'll get this call and say, well, yeah, we need a power of attorney for dad or for my husband. And we say, okay, great, well, tell us a little bit. Well, he's had a stroke, he's non-communicative, he had dementia before that. He really hasn't been able to communicate with us for a few years now, and now he's in the hospital rehab, and they say that we need power of attorney. Nope. There was no way that we could legally sign a power of attorney. That's not a possibility. We'd have to go to the court and get a court order, and then have somebody appointed by the court, and then have to keep going back to the court and report to the court, and you know, possibly have always the possibility of having some stranger appointed as the guardian, or certainly an overseer, the guardian ad litem. And so the idea is you do this when you're healthy. You do this when you're healthy. And honestly, I say this phrase a lot. If you've got somebody you love and trust, you should probably have a power of attorney. If you're over 18 and you have somebody that you love and you trust, you should probably have a power of attorney. This is not just for, hey, we're going to wait until we're sick to do it, because once you're sick, often it's too late. All right. I like this one. Myth is you only need powers of attorney when you're going on vacation. We get this so often that people will call us, especially younger folks or sometimes older folks, but they'll say, yeah, well, you know, we're all going on a plane together, or we're going to Europe, or we're going somewhere, and so we want to make sure we have this power of attorney in place. Well, you probably should have had it in place. You know, sure, come on in. We'll make sure that happens. I know people, they put it off. Perfectly understandable. That's human nature, right? I am just encouraging people not to wait until, you know, sometimes they'll call and they'll say, hey, we're leaving in 2 days. Can we get the power of attorney? Okay, maybe, you know, depends on the timing of things, maybe, but that's not ideal. It's not the best situation. Or I'm having surgery in a couple of days and I want to have power of attorney. You just don't need to wait. Let's get it done now. You know, everything that's going on now in the world, we can kind of see how anything can happen, and we could be otherwise healthy, and we're not planning on going on vacation. And there's lots of folks right now working in hospitals that really wish they had set up their healthcare power of attorney beforehand. Their power of attorney that would say whether they want to be on a respirator or not, right? Their power of attorney that would say whether they want life support or not. Their power of attorney that would allow their spouse to get access to their 401k. A lot of times people think, oh, well, my spouse will still have access because we have everything jointly. Maybe, maybe not. So retirement assets aren't joint. The retirement assets, IRA, 401k, you might have them as the beneficiary, but they're not joint, so they don't have access. So if you get sick, if you die, you might have access. The spouse might have access, but not if they get sick. Now we got a real problem. We got to go to court. Or what if you need to sell the house? So one spouse has dementia, otherwise incapacitated, and now we want to sell the house or mortgage the house or downsize, whatever. 2 names on the deed. Doesn't matter that it's joint. You need 2 signatures to do anything with that. And if we either need to have that power of attorney when the person was still healthy, or we need to go get that court order. All right. All right. Next myth: you do not need a power of attorney when you're young. Not true. We actually have been doing a big push. We're going to push it out a lot more this year and next year. But you know, for the last few years, we've been doing a big push to say, look, you got kids going off to college. We need to, you know, it's a good idea to get them an 18th birthday present to have them come into the attorney and get a power of attorney. they're not going to like it much from the standpoint of they'd rather have money, or they'd rather have, you know, something cool. But it's going to be so important. We have this often where we have a special needs child maybe, and a special needs child turns 18, and the school won't communicate with the parents under certain circumstances, and the doctors aren't supposed to communicate with the parents under certain circumstances. And so we need to make sure we have that. Now, somebody says, well, if you're special needs or disabled, can they still sign a power of attorney? Most of the time, yeah. I mean, we still got to go through that check and make sure that they're legally competent to sign legal documents. But just because somebody's not maybe capable of balancing a checkbook, let's put it that way. Let's say we have somebody that's not capable of balancing a checkbook. That doesn't mean that they can't say who they want to have help them. We don't need to go to a court for that and have their authority taken away. They still have the legal authority and legal ability to say, yes, I want my mom handling that, or I don't want my mom handling that, right? And so sometimes if they're saying no, then maybe the court needs to interfere on that, but to be able to do that so that you have access. Now, what if they're not special needs? What if they're just you know, they got a sports scholarship to go to college? Great, they're in great health, great condition. Guess what? You still, if they go to the hospital, they're not supposed to talk to you. Certainly not supposed to be able to make decisions for them, and you're not supposed to be able to have access to the financial or medical information and make decisions for them and things like that. So honestly, once somebody turns 18, this is really a good idea to have these documents. Myth: parents can talk to their children's school or doctors after they turn 18. We just kind of covered that. That's not accurate unless we have proper legal documents, or, you know, obviously if the child's right there, but if the child got in an accident or something like that, we may have an issue. Or, yeah, you know, there's other reasons why we would maybe want to have access to that information. Let me just look here. Okay, I wanted to cover one other thing. There's no slide for this, but one other thing would be, what about parents for their kids that are under 18? And so is there ever a thing? So one of the things that we'll often see is, you know, parents going away for the weekend, or they're going away for a week, and they live with the grandparents, and they leave a little note that says, my parents are going to take care of my kids for this week, and they're authorized to do anything they need, including medical decisions. Maybe that would work, maybe it wouldn't. There's actually a legal document you can have to make it official. It's called a parental power of attorney. Parental power of attorney, where you're assigning someone to be able to make medical and other decisions for your child while you're away, while you're gone. And it's limited in scope and time. It says this is the scope of what they're allowed to make decisions for my child, and there has to be a time limit on it. And the time limit is, you know, the period of time where you're going to be gone. But it is one of those things that I think is important if you are going to have some issues, you're going to be gone for a while. Maybe you're going on a cruise and you don't think you're going to have access to cell phones the whole time or something like that. Obviously, most of the time you're going to have your cell phone with you. So this is kind of a little bit of an outdated thing, but still, you know, to be safe, it's not a bad idea to have that document when you go away. A form document. Myth is a form document, power of attorney is good enough with someone with dementia. I referenced this earlier, and the bottom line is it's often not. We will often have people that come in and they have a form power of attorney, and their spouse or their parent that has that form document has gone to a nursing home with dementia, or they're in the hospital with dementia. And they're coming to us because one of the things that we do in our office is we help folks make sure they don't lose everything if they go to a nursing home, make sure they're not going to lose their house, make sure they're not going to have to spend down all of their assets. And there are many techniques that we're going to be able to do to authorize that and make sure we protect some assets. The law allows for this, but we have to have authority to do it. And most powers of attorney, especially form ones, but a lot of other ones, don't have that language in there. We call it extraordinary powers, that is only to be used in extraordinary circumstances, like dad's in a nursing home or dad has dementia or something like that. And the idea is that we need to have specific language. And if your document just says, my child, my son can do anything I can do, that's not specific language. That will not work, and we cannot use that. So what do we do? Does that mean that we can't help that family? No, we can still help that family, but often we're going to have to go into court, and we're going to have to get permission from the judge. And sometimes a lot of times the judge will give us permission to do that. The judge will say, oh, look at this particular situation, and I have a situation where dad's going into the nursing home. It costs $10,000 a month, and mom's going to get impoverished if we don't do something to protect her. And the judges will often allow us to do that if we don't have, but if we wouldn't have to go to the judge if we had the language in your documents, if we didn't have just a fill in the blank form, or even a lot of other attorneys don't put that language in there. And we don't put it in every document either. We want it to be specific to your specific circumstances and what's appropriate for your family. But the idea of this is, hopefully you're getting the point that these are important documents about life and death, important documents about everything that you've accumulated, important documents about your bank account, your investments, your 401k, your IRA, your house, your cottage. Sometimes people think, oh, well, I have a will. Well, okay, but what happens during your lifetime? What happens if you get sick? Will's not going to cover that, right? And so that's one of the things we want to kind of talk about, the completing the circle here. Today's presentation was about powers of attorney, and they are extremely important. I think they're one of the most important. I call them the lifetime documents. The lifetime documents, really, really vital. But it should be part of a bigger plan. And so often people will call up and they say, well, I want a power of attorney. And what the team here will say is, okay, we'll come in, you can come in and talk to us about a power of attorney, but we're going to talk about these other things too, because we don't like people leaving our office not being prepared. And so just a standard power of attorney or healthcare document or whatever, that's not going to be sufficient to meet all their needs for the future. And so when people come in, we say, okay, look, we're gonna go over all of this. And if it turns out that all you need is power of attorney, then maybe we're just going to do the power of attorney. But we're going to give you advice about everything, and it's important that we do that. And we'd be negligent if we didn't think about this. If you went into the hospital, you went into the doctor, and you were saying that your stomach hurt or something like that, and all you really needed was an antacid to fix the stomach. But when they were doing their test, they found out that you had cancer somewhere. Should they just not tell you about the cancer? No, of course they should tell you. Okay, well, we can fix the stomach ache, but you got a bigger problem. And that's when somebody calls up and they just say, I just want guardianship, and I just want power of attorney, or I want a healthcare decision. Yeah, okay, come on in. We're going to talk to you about that, but we're going to talk to you about all the other things to make sure that we're doing a complete job and a thorough job on things. All right. So I'm going to ask you, what are your questions? Savannah's going to come on in a second here. I do want to point out that you will have an opportunity, and Savannah's going to kind of go through it, an opportunity to have us prepare documents for you, or at least consult with it. We do have a really great opportunity to have you have like a 15-minute interview with us to see, you can interview us and see whether it's we're right for you or not. And you can even schedule that yourself at your own convenience. So Savannah's going to go through all of that, but let's see if we have any questions here.
Thanks, Bob. Right now, I don't see any questions. If you do have a question, I encourage you to put it in the chat box now, and we'll be sure to respond to that. And while you may or may not be typing your question, I do just want to touch on Bob's point where he mentioned that you would have a way to contact our team. So you will have an email coming to you shortly, any minute now. It'll be in your inbox. And it'll have instructions on how to go about contacting us in two ways. The first way is that if you would like to meet with our team, if you have a question, or you're like, yeah, I really do want to talk to the attorney about my legal documents, maybe you already have them and you want them reviewed, or maybe you've never gotten them before and you're thinking, maybe now's the time. Well, in the email, you'll have an option where you can click and actually schedule a 15-minute interview with our client services director, Katie. Katie has been doing this for years. She's an estate planning expert, and she'll be able to dive into you or dive deeply with you about your concerns and whether or not an appointment with our team would be the best move for you. You'll also be able to ask questions about our firm and also determine, hey, is this the right firm for me? So you can schedule that 15-minute call at your convenience through the email. Now, you'll also have an option if you're not quite ready for the interview call, and maybe you just have a couple of questions and, I don't really want an appointment. I just want to ask something, or, I just want more information. Well, in the same email, you'll have an option to just click and you'll go directly to our website where you can fill out our Contact Us web form. It'll just ask for your name, your email, your phone number if you want us to give you a call, and then you can share your concern or your question. If there's something that you'd like us to cover for another webinar Wednesday, then you're more than welcome to leave that feedback there in the Contact Us box. So again, be sure to check your email. That should be there any moment. And if you do have any questions about what Bob talked about today, even if it's a few days from now, please feel free to follow up. Tomorrow, I'll be sending the replay of today's webinar, so you'll be able to catch anything that you missed, and you'll be able to share that with family and friends. Thanks again for joining, and we'll see you next week.